Are you thinking of moving to Colorado, or do you live in the Colorado area and you're looking at buying a house? Are you wondering exactly what is a post-occupancy agreement and how does a post-occupancy agreement work in Colorado? Well, today we're going to cover the post-occupancy agreement, which is part of the Colorado buy-sell contract. And we're going to go over the 17, basically provisions in this to kind of cover them so people can hopefully better understand what a post-occupancy is. And basically, a post-occupancy allows a seller to occupy the home for a specified number of days, basically renting the home back from the new purchaser or buyer. Now, when this comes into play, the one important thing in all this is the maximum you're allowed to get after closing. And I stress after closing, not the contract, but after you close. The maximum you can get one of these for is 60 days. So if you're a buyer or a seller, you both need to know that 60 days is max if the new buyer is paying new buyer is getting a loan. Now, it doesn't affect you if you're paying cash, because then the lender has no bearing on this. And you might ask, why does the lender have any bearing on this, and why 60 days? Well, when the new buyer has taken a loan out on the purchase of your home, the lender basically has underwritten the loan that they're going to occupy the property. And within the deed of trust, there's a clause in there that the buyers will in good faith move into the property within 60 days. And if they don't, the lender can say the loan is due in full because basically they're in default of that clause. So that's why it's a very, very, very important thing that 60 days that you know this up front, because that's the maximum you'll get, again, unless somebody's paying cash, of course. So anyway, the Colorado post-occupancy agreement has 17 sections like I stated before, and we're going to cover those today. And anyway, the first one in there, number one, are the parties. So basically the parties are obviously the people that are on the contract, the buyers and the sellers. Now, one thing to note, the contract cannot be assignable and it cannot be transferred to anybody else. So it's just between the buyer and the seller. And then number two, we have the agreement. So we have the agreement. And so the post-occupancy goes with the original executed contract to buy and sell. And the post-occupancy can be subject to the amends of the original buy-sell contract, or you can amend the post-occupancy agreement itself. And again, the post-occupancy is always conditional upon closing. So if the closing does not happen, the post-occupancy is basically null and void. The next one is possession. Hopefully you guys can kind of see my scribbling here and see it's pretty small. I need to get a bigger board. Basically, the possession now lays out the term or the days of the post-occupancy. And again, like I said, it's non-transferable, so it's just between the buyer and the seller on the contract and basically nobody else. Number four is an important one, and that's maintenance. And basically, what maintenance means is really all the items that you be responsible as the new homeowner you the buyer. The repairs such as the HVAC system, the plumbing, the roof, the new buyer is basically responsible for that because it's their home. And the seller, they have the right, or actually they're obligated or within their, just basically to maintain the landscaping, snow removal, lawn care, and then also the seller under this clause has to notify the buyer of any issues that went on with the house, or that happened, anything that breaks down and so forth. So the next one is damages. And damages, I'd have to say, doing these post-occupancies, the new buyers are always concerned about damages. But basically within that clause, it just says that the sellers will still keep the property in the condition that it was at closing. So, and then the next one is the buyer access. That is buyer access. Basically, like a lease in just a regular rental, the new buyer has to give 24-hour notice. And if there's an emergency, then like in any lease, they don't have to give the 24-hour notice. So that's basically an important one too. You just can't go into the house unless you give thorough notice. Basically, number 7 is the restoration. And basically all that's in a nutshell saying is that the buyer has the right to restore the property or items in the same condition as closing. And if the seller does any damages, these kind of go together, I think, then the deposit gets applied according to Colorado law. And by the way, I'm going to put the disclaimer up here. If you're wondering more about the laws and everything like that, consult an attorney. Everything I'm covering here today, I am not giving legal advice. So I just want you to know that I am not an attorney. I'm just kind of breaking down my interpretation of it from doing it through the years. Anyway, the next one on here, number 8, is important to some. It's actually the important one on the whole thing, but it's the rent. Really within that contract, and you're in a bidding war, a lot of these people, you being the buyers submitting your offer, you may not ask for any rent just to try to get the deal. There are some people still today that ask for normal rent, just as if it was a regular lease, because they feel like they're going to have a mortgage payment coming up in the 60th day and they want to kind of offset that. So anyway, the rent is in section 8, and then it also breaks down if it's prorated or not, just in case you leave early and so forth. Anyway, we'll get into number 9 here, and again, it's compliance. And basically, compliance, let's back up here. Let's redo that. Compliance with the law, the seller has to abide by all the laws and the ordinances. And and again, if you want more, again, when we were talking about laws, things like that, I'm going to stress to you to consult your attorney on that. Number 10, and this can be an important one that people are worried about happening, failure to vacate. So what's meant by failure to vacate is when you get to the end of the post-occupancy agreement and on your 61st day you're still in the property, it's spelled out in there what the per day charge is if you haven't left. And that can be anywhere from $100 to $500 per day. So far I've been pretty lucky through the years. I haven't ever had to utilize the failure to vacate. Anyway, number 11 is the water and sewer. And basically, when you as a seller sell your house, right away the title company transfers the water to the new buyer, because water will file a lien on the title report, or on your title to the property, I should say, if you don't pay the water. So that's why they transfer it. So usually this section here is usually checked that the buyer will pay. Number 12 is the electrical and gas. Basically in there again, like the water and sewer, the electrical and gas is broken down who's going to pay it. And usually in a standard post-occupancy, at least the ones I've been involved with, the seller will pay this since they're staying in the property. Number 13 is seller's renter's insurance. So basically it just has a provision in there, and it'll be checked that the seller will or won't maintain renter's insurance. And if you don't know what your homeowner's insurance policy is, if you're selling your house, maybe give your agent a call, because usually they can flip you into a renter's policy. And anyway, a renter's policy is rather cheap anyway, covering the contents inside the place, but you will probably more than likely need to get that if you're a seller and you're staying in the place. 14 is the buyer's insurance. That is buyer's insurance. And basically that's just, they're gonna get their own homeowner's insurance, or they may get a landlord policy in the meantime, because they're basically renting the house to you. So again, you'll have to talk to your insurance agent about this. I'm not an insurance agent and I'm not an attorney, so I want to make that clear. Number 15 is the security deposit. And basically what that states in there is that the new buyers will hold an amount of money for any kinds of damages and such that happen to the property while it's in possession of the seller. And the buyer will hold the money themselves. Title companies used to do it. Everyone I deal with, the title company won't do it anymore in case there's a problem. So the buyer will hold the security deposit. And then once the post-occupancy's over, no issues, the new buyer has to release the security deposit in 30 days. Number 16 is the attorney fees, costs. And basically what it says in here is that the court must award cost to the prevailing party if there's ever any issues. And then number 17, just like the contract to buy and sell, we have the additional provisions. We can get it on here. I need to get a bigger board. Anyway, that's provisions. So in the additional provisions, like in the body of the in the contract, we're going to have the agreement with the dates and so forth. I'll usually see it as a listing agent. If somebody sends one over, they'll be more clear on the exact date again of when possession's given up. Also, that the house needs to be professionally cleaned and what time and everything else. So this kind of, as it says, additional provisions, just adds additional clauses to the post-occupancy agreement. So really, at the end of the day, the post-occupancy agreement is a great tool to win bidding wars out here in Colorado, especially if you're moving here from out of state. If you live here, I'm sure if you've been offering on homes, you've probably presented these before. But if you're going to write an offer, be prepared to include a post-occupancy agreement, because most transactions, at least 90+% of them that I've been, or 90% I should say, plus of them I've been involved, they have this. So be ready for that. And again, if you question anything within this, anything legal wise, and you need clarification, always consult your attorney. Again, I'm not giving legal advice on any of this. I'm not an attorney. But anyway, when this is laid out correctly, both parties, they usually move on afterwards, and there's never issues whatsoever. But again, you do have to protect yourself in the event that one of these 17 provisions gets broken while the post-occupancy is in place. So anyway, I hope you found this information beneficial. And if you would, go to the bottom and give me a thumbs up or thumbs down. And my contact information will be in the body of the post below as well. And feel free to reach out to me anytime with any questions at all. I'd be happy to answer any questions. I'm David Novak with David Novak Homes and RE/MAX Professionals. And I hope you have a great